request to sell. Yes.
Trustee Moore.
Item 8.
Thank you, Mayor Lofgren. Sorry I was late. So I'm here tonight, and those three, in discussing that with, and vision in here for that, there's enough water associated with those shares to cover the proposed development through the court process. We're taking those 8 shares through the process also, and so then they could immediately transfer a portion of those additional shares to you to cover that shortage. Normally you have a holdback provision on water certificates and taps, usually 20% of the overall development. We don't like to give them all out before we get through water court to make sure we're okay. Rather than having that holdback provision here, they're putting up 20% more water, which we thought was acceptable. The way the agreement now is written, that the additional shares, that additional 20%, if you get through water court and the original shares are enough to cover the development, we're going to give back all of those additional shares. The hope is that they'd actually would then come back someday and dedicate those for some other subdivision in Lac Bowie. They won't be able to use it in Lac Bowie without, another agreement with you. But they decided they didn't want to sell those additional shares to you. They needed them for some other developers. So if there's any excess in the original shares, you can buy that. If there's any, if the additional shares are not needed, you have to give those back. The third issue was whether or not they could convert those additional shares or any excess water into more certificates and then use those in the town. And we had a disagreement between us as to whether or not that was appropriate, because they weren't giving the town, through this agreement, any additional capacity in the diversion and pipeline and storage facilities, so they'd have to do that. They're only part of the way there. And rather than try to draft all that into an agreement and have us have to negotiate in the future, they just said, look, why don't you just, to the extent there's excess water there and the additional shares, give that back to them. And then when they come back, or when they're ready to come back, they'll bring everything to you and do a whole separate agreement. So I thought that was an appropriate way to fix it. So there's still a chance to get some excess water. So the agreement that we presented to you, it really doesn't have any other substantial changes from the last one. There was one other change in addition to the exhibit, which I had forgot to attach. After we submitted this to the staff to circulate, and you may recall that was another one of those snowy days where you shut down early. And we tried hard to get it to the staff on time, but we didn't. So we submitted it, and then I thought about it overnight, and I called up Bob and I said, look, Mr. Lemke, I said, I still have an issue about how we're describing this vested carriage right. I'd feel better if we described it a slightly different way. So I made one additional phrase in one of the paragraphs to clarify that, and that is included in the final version, that you didn't see that phrase. Be glad to read it to you. I also have copies of Redline. We just also fixed a couple typos. Those are the only other changes that we did, and you haven't seen those, but they really are just typos. One is a phrase that was hanging out there that we put in somewhere else in the agreement, so we took that out. But if you have any questions about the agreement, or if you'd like me to summarize some of the key fees or other key terms of the agreement, I'd be glad to do that, or I can answer any of your questions.
Strap?
I'm sorry, I got so many questions, so that's probably because I hadn't been here. But so as we start off, there's 100, let's call it 132 acre feet of annual water, according to the agreement and the certificates. And then there's the 55 acre feet of water that is consumptive use.
Right.
And so you got to help me try to understand this. So this water is coming down the Platte, and it's going to get diverted, and at one point it can go to our the United Storage Reservoir, and they're going to give us like 45 acre feet more in that reservoir, that at some point we can, if we want, we can exchange for storage in the highlands. So I guess what my question is, and for the most part, they have the 68 acre feet of water that they're moving around all the time, and they're always making sure that we have that consumptive use water. So as that water's coming down the Platte, To me, it goes from 132 acre feet to the 68 acre feet that we're taking care of. So the other, I don't know, 118 acre feet is going on by. And is this where the augmentation stations are that we don't really have any agreements on yet? And so we're making a substitute water supply thing to let that water go on by us and downstream. Is that really right?
Well, here's the way it works. So these shares are historically used for irrigation. So they get diverted through the Fulton Head Gate and down the Fulton Ditch to these farms. And that's the 138 acre feet of water that historically went to the farms. When you do that, you have a portion of the water that goes on the fields and then comes back to the river as return flow. And the rest of it is the 68 acre feet of consumptive use. And when we do water court transfers like this, in this way, we would only be able to use the 68 acre feet of consumptive use and then suffer some losses in delivering that back to the river, exchanging it up and delivering all the way through here. That ends up being 55 acre feet by the time it gets to the town. So there's really no augmentation going on over there, but in the change of water right, we have to put back the return flow so we don't injure any other downstream water users. It's just an obligation in that kind of a change case to protect people. So we deliver that through the augmentation station, so it goes from the Fulton Ditch back to the river. It's all gonna come back in the summertime, and some of that water historically came underground and didn't make it back to the river till the winter. So to protect those winter users, we will have to store some of that water in United, carry it over in the winter, and release that back to the river in addition to some of the water coming back in the summer. So we lose over half of it. We don't lose it, but half of it is truly just return flow water, and we can't transfer that. And then the rest of it is yours. And what we do is we calculated it here at the city, and we say, you need 55 acre feet. But to get it here, we're gonna suffer losses. So you have to give us 68 acre feet over on the river so we can get it here and cover all your depletions.
So that other 120 acre feet, where does it it just goes down the river to someone else?
It gets delivered back into the river. It goes downstream to people who have historically relied on it, and they're entitled to rely on it. So we have to put it back.
I think that was really it. The dry up covenants, is there any reason why we don't really get a location of those properties? Or
What do you mean we don't
am I
get-
misunderstanding that?
You mean, why isn't the location described in here?
Yeah, for the dry up locations, when they,
The dry up is associated with the historical farms. I was looking through the title documents today and yesterday. We're getting a title opinion from the water attorneys representing United. And so the shares came from some farms historically. Those previous owners have signed dry up covenants that says that we can dry it up and take the credit. And as part of the transfer of the shares and the water rights, we'll get both a deed and a stock transfer. Previous owners have obtained dry up covenants, and we will get assignments of those covenants so that we can ensure that those properties remain dried up and we get the credit. And so I still need to talk with Matt Poznanovic, is the lawyer representing United in this for the title opinion. Matt and I need to talk about that and confirm that we're going to get assignments of those dry up covenants.
I kind of wondered, I guess it probably doesn't really matter to us where they're doing that. It's just kind of interesting. If you kind of knew what properties had been dried.
Yeah,
up
we
over
didn't put the
time.
details in here about where the farms are located. That's in the title documents, and we'll have to disclose that in the water court application that we're going to file. But that was just the level of detail we didn't think we needed to put in the agreement.
Well, this document gets easier and easier to kind of understand. I mean,
10 more of
kind
those and they'll make sense.
Yeah, I mean, on page 8, on 13 or 3.2, the third to the last word in that is TT, and it's just a spelling error.
That's one of the typos that we fixed.
Okay.
Yes, thank you.
That's all I have. Thank you.
Trustee Morris?
Thank you. Two questions, if you could elaborate on. One of them is under paragraph 7.8.2, the terms for the town to purchase back any or all of the excess consumptive use water at a set price of 22,000 per acre foot.
Yes.
Elaborate on that, specifically the terms or conditions for us to purchase back water.
Well, the price was something that we determined actually in a previous agreement with a different developer, but the intention of the price term is based partly on the price of buying the water and partly on the price of adjudicating the changes, because we are making United, in this case, pay for all of that. And so part of this price relates to that. Then they added in a request for a 3% increase over time. So we think that that's a reasonable price, and of course you don't have to buy it. You could say you don't want it. But that's the price that we simply agreed to. The other terms and conditions just are that to the extent that you are acquiring the water rights by a warranty deed or special warranty deed, you'd convey them back by the same quality of deed. You'd have to also transfer back stock in the Fulton. If we end up with 8 additional shares, you would transfer those back. Originally, we also had a provision in there, and I hope it's not in there anymore, that if you were to buy any of the additional shares, they would have to give you or transfer those to you by the same type of deed and assignment, but I think we took all that out.
And if you could help make sure that I or we understand what you mean by the excess consumptive use water.
Right, so the consumptive use is the 68 acre feet of water. And actually, the way we've described it, there's another term in here that describes the total firm yield. And I don't remember the exact location, but it's roughly 55 acre feet of water. And if we get through water court and we're able to prove that the 39 shares yield, let's say, 60 acre feet of water, the difference between the two is the excess consumptive use water that you could buy, as long as it's associated with 39 shares. You know, we may end up with 60 acre feet, but some of it's going to be related to the other 8 shares, and we won't count that as excess consumptive use under this agreement.
Thank you for clarifying that. The second thing under paragraph J under the recitals addresses the fact that United doesn't have any rights to or use of head gates or augmentation structures, et cetera, and that about delivering water rights back to the river by payment of cash in lieu of constructing capacity. So there's that clause, and this may be unrelated, but somewhere in the meat of this, it mentions that United is in the middle of constructing structures. Are those two issues related, or are they two separate things?
They are related.
If you could clarify and comment on those.
Sure. Those are related. They've been talking for a while about building a augmentation station on the Fulton ditch. The ditch is in 3, sometimes when there's not enough water to go around all the shareholders at one time, they go into sections. So the first part is section 1, and the middle part is 2, and the last part further down towards, well, the north end there is section 3. They're trying to build a structure right in between 2 and 3. The company, the Fulton Ditch Company, has articles and bylaws or rules that says that when they go into rotations like that, in order to prevent injury to other shareholders, if your water was historically used in section 3, you have to return it to the river in an aug station in section 3, same thing with 2 or 1. And if you try to move up the ditch, right now they ask you to leave in more water in the ditch, so you lose water. The concept that United is pursuing here is building a structure right on 2 and 3, so that they can deliver water from either section 2 or section 3 through that structure back to the river. But it's not done. They're still acquiring easements or rights of way, and I believe they may be in condemnation for one piece of property to get an easement. And so they haven't built that structure yet. So we drafted this knowing that they didn't have a structure similar to what we did for Silver Peaks East, and we asked them to pay the same type of fee so that we could go out and purchase the right to use an existing structure. There are some existing structures out there, where we can either get a permanent right or more likely a long-term lease. And so we're exploring that. We have been talking to Fort Lupton about using their structure under that type of a long-term lease. And so as we were discussing this with United, they said, hey, we are building this structure and we'd like you to buy it from us rather than somebody else. And we said, well, we don't want to have to wait if it's not done. And so we drafted the agreement so that we would have the right for the town to go ahead and purchase rights in an existing augmentation station if we want to, if we think that you can wait and it makes sense to wait, and we're talking, they're not really going to talk price with us until they know what it's going to cost to build it, and they don't know that yet. So there's a lot of variables there as to whether or not they'll have it done in time, and we may not want to wait. So we have the ability to go ahead and buy it. If we haven't bought it by a certain time frame, it says that we'll come back to them and talk to them and try to negotiate, but it's entirely up to the town as to whether or not you buy into their aug station or not. So it's just an option.
Hop over to Trustee Doherty and come back to you. Yes. Trustee Doherty?
One of the things you brought up in the last one was their request to be able to use these shares elsewhere in town. We've not accepted that, correct? I didn't see that we left that in there, but.
That's correct. These shares can only be used for this particular subdivision, and that issue was kind of hanging out there because we were talking about issuing certificates for the additional shares, and we just took that out of the agreement.
That's what I figured, but thought I'd double check. Thanks.
Chris?
Defer a little bit more.
I think you might be the only one that has questions left, though. Oh, Trustee Stroud.
So in regard to Trustee Doherty's question, the 7.9, it says that they can make those use available just about anywhere in town. So does that clause come out of here?
7.9 does not say that, I
Okay.
hope. I think that 7.9 is something that we actually had left over from what we put in the Silver Peaks East agreement, and it really is just an option. We were exploring the possibility of entering into another agreement with another municipality where we might trade these shares to them in exchange for water service contract by pipe, or we might trade it to somebody in exchange for an entirely different water source that might be upstream, that might be easier to use without an augmentation station. So that paragraph is just sort of a catch-all for the benefit of the town of Loch Buoy as to whether or not you might want to try to do that. And they were okay with leaving that paragraph in there, but that really just gives you some discretion.
All right, thank you.
Anything else, Trustee Morris?
My marker's down.
Okay.
I yield.
So, seeing no other comments or questions, I will entertain a motion.
I move to approve the Water Resource Credit Agreement with United Water and Sanitation District and the town of Loch Buoy. Is that correct?
Second.
I have a motion and a second. Roll call, please.
Trustee Morris.
Yes.
Mayor Lofgren.
Yes.
Trustee Ott. Trustee Jeffrey. Trustee Strock.
Yes.
Trustee Doherty.
Yes.
Motion carries 6-0. Thank you, Mr. Dyer.
Thank you.
Next item is ordinance number 2019-640 concerning weight limits, it looks like. Ms. Strawn or Chief McCoy?
On this, are you able to hear me? This is Maureen Duran for the record. Thank you, Mayor. Before you tonight is ordinance 2019-640. The police chief and I were in communication a couple of months ago about enforcing weight limits on town streets, and spent a little time digging through the code and the ordinances that we could find to determine whether or not we actually ever codified the weight limits restrictions on the street, and we were unable to come forward with a signed ordinance. I can't really explain what might have happened at that time. So this ordinance, consistent with what state law grants local authorities the power to do, adopts a weight limit on all streets in town of 10,000 pounds, except for Weld County Road 37, north of Weld County Road 4. You see there's an extra preposition in there. Entirety of Weld County Road 4 within town, the entirety of Weld County Road 6 within town, and the I-76 frontage road.
That's currently if you see the signs as we're driving through where it says truck route, that is the truck route, that defines the truck route. So we have signs up saying that it's illegal for vehicles to be of that weight on city streets, but we don't have an ordinance backing those up. So it's time to get one of those, I think.
While I have the chief here, did I miss Weld County Road 2? Or do we don't enforce a 10,000-pound weight limit?
No,
on
Weld County Road 2 also needs to be on
Be
there,
included, so
or
we're only on here for
168, whatever you
discussion
want to
tonight, but we
call
would
it.
add Weld County Road 2 to that list. So that's the first half of that ordinance. The second half of that ordinance sets an absolute speed limit within the town. Right now, our ordinance, what the law says is that a posted speed limit isn't necessarily absolute speed limit, and you can prove that the conditions are ripe that would allow you to potentially go faster, unless the jurisdiction has adopted codes setting absolute speed limits. And we have this entire list of streets in town that's kind of outdated, frankly. It doesn't address any of the streets in the newer subdivisions that set differing speed limits throughout town. And so what the chief and I discussed in better approach for the town really is to just set a 25-mile-an-hour speed limit throughout the town, unless the speed limit is posted differently, and give the chief then the flexibility to put up signs depending on what he's seeing as far as just increased traffic, safety concerns, that kind of thing. So this would set that speed limit absolutely at 25 throughout the town, or as whatever is actually posted. And so if somebody was going faster than this posted speed limit, they can't wiggle their way out of it, if you will, by making some sort of an argument that the road conditions were so beautiful that day that it was okay for them to potentially go faster than the posted speed limit. So that's what the point of that ordinance is. I don't know if you have anything else to add.
Yeah, so generally, and it won't affect school zones. Those will still go down to the school zone levels that they are currently set at to be slower. And currently, right now, 37 is faster than that, County Road 4, County Road 2, and those will be faster than that. I think that they'll set higher speed limits than 25. But most of our roads are residential, and I think that then, like County Road 2, for instance, when that gets finished, maybe that's a 40-mile-an-hour road, not a 30-mile-an-hour road. Maybe it's not. I don't know the answer to that, but I think that this cleans up all these different speeds, and some are 30, some of them are 25 in certain residential areas where it seems like they should all just be the same speed. So, and it makes it easier for everybody. I think it makes it easier for signage and for enforcement.
And just one other thing I want to add by way of background, I probably should have opened with this, but this town of Lochbuie is still operating under the model traffic code from 2003, which seems a little outdated. The Colorado Department of Transportation did promulgate a model traffic code in 2010 that we spent a lot of time looking at, and it just was frankly full of issues for local governments, where we would do so many amendments, practically the text of the amendments would exceed the text of the entire model traffic code. So they started then in 2016 an endeavor to adopt a new model traffic code. It was supposed to be a 2017 version. They did promulgate that earlier this year as a 2018 version. And again, it's been identified just to have so many problems that the Department of Transportation, actually with my office, is the one that was talking with the gentleman down there. He ended up finally sending it to the Attorney General's office. Apparently he had put it out without checking with the Attorney General's office. So there's somebody in your office, the Attorney General's office, who's actually a former municipal prosecutor who's now working on that 2018 code. So our goal initially was we were sort of waiting on all this, waiting to see the 2018 come out, and then we were just going to make our amendments. But I have a feeling that 2018 is going to be pushed into a 2019, and we really just can't wait anymore because we have been enforcing these rules, and we just want to make sure that we've got our I's dotted and our T's crossed on that. So.
Other comments from anyone on the board? Trustee Morty?
Yeah, the weight seems really, really low. And maybe I didn't see that we have provisions in there to cover this, but do we need to get one every time that we have a fire call? Because I think most of the fire trucks are gonna go over that. Most of our garbage trucks way over that amount. And then the other thing that I'm also concerned with is anytime there's construction in town, concrete trucks all weigh more than that. So if,
There's
somebody needs to pour a driveway or a sidewalk that they're being required to fix, they're gonna have to get, an ordinance, or not an ordinance, but they have to get, paperwork to pass to allow that concrete truck to come into town.
There are provisions for local delivery, which covers all of those things.
It does? Okay. I mean,
Section 3 of the, so, we need page numbers. Section 3 of the ordinance, at the top of the page, it says 10. 5.13A2 on that page, it's the 1, 2, 3, 4th paragraph down.
okay. No, I actually,
Deliveries in normal course or in a residentially zoned district while making deliveries, or it's illegal in a residential district except while making deliveries in normal course, so.
so does that cover a fire truck that, are they delivering water?
They're an emergency vehicle.
Okay. I just want to make sure, that we're covering all of our bases on that, so that works.
I think that's a good comment, and I'll make sure to amend this to make sure that we accept emergency.
Jack?
My comment really on that was, an F-350 or a 3-ton Dodge truck is not really that big. That would be, I guess what you'd call a Class 3 vehicle, which is between 10,000 and 14,000 pounds, whereas the other's in a 2B. So, I just don't know how many people, I don't think you should be able to tell people they couldn't buy an F-350 and drive it around town, if they just wanted a big cowboy truck or something. So that was kind of my only question, because you'd have, I don't know if it would match that weight limit or not, I guess.
F-350 over that much?
Pardon?
Is an F-350 way more than that?
Well, so it'd be what, a 350 would be what, 7,000 pounds, so maybe it would be under that
I
10.
think it's under that. I think if you had it loaded up with something, maybe, it could have the capacity to carry a load that would be overweight, but I don't think just driving that truck is overweight.
I think you're right. I was thinking it was over, so sorry about that.
Is that right, Dave?
No, mine weighs 6,600 pounds empty, and it's got a 1-ton carrying capacity, so that puts you at 7,600. You add dual wheels, it puts you a little over 8,000. But the towing capacity is way higher than 10,000, but the carrying capacity isn't, which is what this covers. Yeah.
Trustee Morris?
Thank you. I have the same concern as my esteemed colleagues. The section 513 about keeping, storing, and parking vehicles prohibited, et cetera. It talks about semi-trailers, trucks, tractor trailers, et cetera. And the last item on there that doesn't seem quite right is it says a truck of 2-ton carrying capacity or more. An F-250 has a carrying capacity of over 2 tons. An F-350, 450, or anything equivalent has a carrying capacity. So my concern is that if that item is in there, that we're effectively prohibiting half the trucks that are in our town or in our community. It doesn't say anything about if they're loaded or not. It just, this language, I have a little bit of concern with. And does that also eliminate people's work trucks? Like the F-350 or 450 chassis with the flatbed with all their equipment stored on the back? Would it eliminate that as well? I think we might need to revisit this. Let's see. Item 2 on there has it restricted to any residential zoned district in the town. But do we want that to encompass the entire town? And I guess what comes to mind is the farms area is what, an R3, R2, R3, a residential?
Rural residential, but it's residential.
Wanted to apply to that area? For example, there's a lot of homes up there that have RVs and I think a tractor trailer that somebody uses for their work that they store on their property.
Actually, that's part of the problem with that we have is with that specific tractor trailer. That should not be in town in a residential area. That's, I mean, they shouldn't be driving it on a road to get it to their residents. So that's a specific issue that this is addressing, is complaints that we've had about that particular thing.
So if I may just say, just so we all know, this language, this new section 513, this is not new language. This board actually considered this language and all these very legitimate concerns a couple years ago. But again, this is something that for some reason has not been codified or showing up even in our list of ordinances with the codifier to be codified. So from my perspective, I just stuck the same language in here as had been vetted before. But I think you raise a legitimate question about the 2-ton carrying capacity,
Yeah, I agree.
whether
Yeah,
that should
that
be
shouldn't
in
be
there
that
or
way.
not. But that's a policy decision, so we're here for discussion on that.
Seems like, to me, it should be the weight limit, that you should not exceed the 1,000 pounds, not anything less than that. You should be able to drive it.
That might be a little bit more applicable.
Want to have any,
Go ahead. I was gonna make
Trustee Ott?
clarification purposes. For clarification purposes, an F-350 is considered a 1-ton truck. So it has a carrying capacity of a little over 2,000 pounds. An F-450 is a 1.5-ton truck. An F-550 is a 2-ton truck. They weigh about the same empty. Okay, like my truck weighs 66. I've weighed it innumerable times because I get stopped towing race cars. So my truck weighs 6,600 pounds empty. It's a 1-ton truck. Okay, so you add another ton of that, 2,000 pounds, you're 8,600 pounds. So you're still under the 10,000 pounds, what you're supposed to legally carry. Now, the towing capacity is a totally different deal. You see, they say it's rated for 17,000 pounds or 24,000 pounds. How much weight you can tow, not how much weight you can carry. Because my truck has a much higher towing capacity than it does carrying capacity.
so are you saying the concern that Trustee Morris is raising is,
I really don't think it
okay,
would apply. I mean, you have to get to an F-750 before you get over 10,000 pounds.
Talking
But I
about
think
what,
that if-
GVR, gross
Yeah.
vehicle weight?
Mhm.
I think I agree with you. The numbers that I pulled up, an F-250's payload / carrying capacity, 2,400 to 4,300 pounds. So it could carry over 2 tons. Payload.
Right, with 2 tons, you're gonna be
not
looking
to-
at the sky.
Right, but I think if
Well,
you limit,
I guess my concern is that it could be argued that a homeowner's pickup truck exceeds what our code would say if we left it in there as,
Let's say you put 4,300 pounds in my truck.
let me finish, Dave. My concern is that if we leave that language in there prohibiting a 2-ton carrying capacity truck, that we're gonna run afoul with half the residents in town. Because there's a lot of people who drive trucks that can carry in excess of 2 tons.
so is your suggestion just remove that provision and leave the 10,000 pound weight? Okay. Trustee Stroud?
So, I think I forgot to put my thing, but I agree with that statement.
Is there anyone who
10,000
disagrees
pound.
with that for any particular reason? So it looks like you have consensus to remove that and just leave the straight weight limit.
And then you had County Road 2, paragraph, section 1, paragraph 3.
Any other questions or concerns that we should send out? Trustee Doherty?
Unless we consider kids a delivery, school buses would also be something that's over this weight limit. So,
Governmental agency, governmental trucks, I'll put some language in there.
okay, just as long as we're,
Yeah.
I think
we're not gonna
you
write
guys
that
laugh,
ticket.
but I think we need to make sure we're covering our bases. I get that it's still up to you guys to enforce, but if
No, it
it's
makes
what the
sense to me.
code says, it's,
Makes sense.
Anything else? So I think you have your direction on that one. Do you need any other direction from us, Maureen?
No, I think not. I'll bring it back and we'll put it on for action, and if you have further changes at that point, we can always continue it.
Cool. Next item for discussion is resolution, or ordinance number 2019-641, constructing roadways, it looks like.
also is coming as a result of conversations I've been having with the police chief lately, too many conversations.
Yeah, a few conversations.
With the code enforcement officer and just concerns he's had about people placing objects, frankly, in the town's right-of-way in front of their property, and sometimes for the purpose of project, but I think also sometimes for the purpose of parking on the street in front of their house as though they own the right-of-way in front of their house. And so as a result of that, we drafted this ordinance that really would provide that you can't obstruct the public property, but that we would allow for a permit program so that if you needed to, for instance, have a temporary dumpster while you're doing a renovation project, or a portable toilet, or even one of those storage pods while you're moving out, you can come into the town and fill out an application and tell them why you need it and how long you need it for, and the town can issue a permit for that. About a fee situation for those permits. And obviously lawfully parked vehicles would not be considered obstructions on the public right-of-way, but even things like putting cones out there in front of your property that say no parking would be obstruction of public property in the public right-of-way, so big a ticket for that. So there's that. And then we carry this a little bit further because code enforcement's had some complaints where people had those things not just on the street in front of their house, but also on their property visible from the street, and for sort of an unreasonable period of time, I guess. So we're also in this ordinance extending that permitting program so that
or whatever, parking, people, you know, they have their own and put there, okay, small folder, put, wait, the, you know, difficult. We thought we heard that before. We've been telling people to move it, and Andrew pointed out that we can't find anything in here that stops that from happening. So we've had that, and then also we've had a problem over here in Lockwood with a person that's cleaning up their property because they've been told they got to clean it up, which is really good. But they have a big dumpster parked setting in the roadway, you know, where you would park for just an extended period of time. I think they've taken at least one load to the dump, but then it's back again. And so we could tell them, move it on your private property. The only place you could put it would be in his driveway, and then it would be there for however long. So I think that in landscape material and all those things that you can, a lot of times you'll see people put that in the road for a temporary period of time, but sometimes people don't finish their projects. So then they get stuck there for a longer period of time. So that's why I think the permitting is a good idea as well.
So I guess I have a question about staff resources for this. If we're gonna require this for any time someone has a pod in their driveway to move, do we really have the staff resources to issue these kinds of permits for every time someone is gonna move?
Yeah, I don't know how often that happens, and I don't know how often somebody blows in there on Saturday and they unload their pod and they're out of here, then they are, right? Nobody's even gonna notice it. I really think that what we're talking about when it becomes a problem, right? We need to have a tool to not allow somebody to not finish that project for 6 months or have that.
Right, but we're
whatever.
still requiring people to get a permit anytime they have one of these, right?
including frankly even like a dump of mulch in your driveway or in front of your house on the street. This would require a permit under this process. And I don't know if any of us know the answer to the staff resources. It's a very legitimate question.
I think it is. I also know that, you know, people need permits for things, for a lot of things that people do without permits. I'm not advocating that they do that, but they're not going to know there's not a permit, that there's going to be a permit required for this until we tell them. So until they leave their pod sitting out there for a week and we're like, hey, you need to get a permit to keep that there any longer. At least that's the way I see it starting off. I mean, maybe it doesn't stay that way. But I think that allows us the enforcement portion of it after we've noticed it as a problem, that we contact the person and say, hey, you're against this ordinance. Now you can keep it here, but you need to go get a permit.
And I don't want to cut everyone else off, but I have one more question. So what if we did, the roadside stuff makes sense to me. You have to have a permit anytime you're doing it on the road. What if we did like if you're planned to have it there more than 72 hours on your driveway, then you need a permit kind of thing?
Good to me.
Trustee At?
That's exactly what I was gonna say, 72 hours, 3 days, you know, for storage
So we
pods. If it's on your private property, you've got 3 days to either get it there or get a permit. And, the other thing is just a minor thing. On the first page, the bottom paragraph, they misspelled storage. Steerage, or steerage.
Trustee Strack?
Sturgeon pods are actually witchweed.
I stretching.
So if they're growing witchweed out in front of their house, we have a problem because the rodents will be attacking the witchweed. I think it's probably a good thing, an item that could be in the newsletter, saying you can't put these storage containers out in your house, just to kind of.
Trustee Jeffrey?
I also agree with 72 hours. I also like landscape delivery people, like when I got rock to finish my landscaping, like they want to put it on the street. They do not want to put it in your driveway. And so I think we should consider, you know, a short period of time to allow that for that sort of delivery as well. Maybe it's not 3 days. But give them, I mean, they made me sign, like, if we crack your driveway, and mine's on the slope, so I'm like, you're gonna dump it in my driveway, not on the street, because I did one delivery on the street and that was too much. So I just think sometimes, like, they really don't want to open that can of worms, and we wanna not make things super difficult for our residents.
Trustee Morris?
When we're talking about obstructions to the public right-of-way, and we've got construction materials and debris and dumpsters and landscape stuff, do we want to maybe think about, or I guess maybe a question is, has this already been addressed, but would we want to look at or think about adding essentially a camping ban? Putting it in the code that it's not legal or allowable, or giving the police teeth to enforce something to prevent people from setting up tents or
Already have that.
shelters. We do?
And we might have did it right before you got
But we
on
have it
board.
relating to RVs. We don't have a prohibition on camping in a tent on your yard.
We're not like other major metropolitan cities or areas that do have camping bans, but you never know, one day the zombies and so forth might. One day we may have people trying to camp on the sidewalks or on public right of way. And if that's not been addressed, that might be something to look at or consider.
I think if we're gonna have that discussion, separate from this though. At least that's my, Trustee Doherty?
A couple of things. I think we should be a little careful about allowing it and having dumping in on the right of way, just because in like Berkshire, where there's only technically parking on one side of the street. So if we allow it, I think we need to make sure that it's specific, that it's on the, basically in the parking spaces, not in the drive lanes. Because I think when we have the areas that don't have parking on both sides of the street, you're going to really need to limit it from the people that don't have parking on their side of the street. Otherwise, they are blocking traffic lanes, which I think is inappropriate. And I get the point of having it on the driveway, but I think it's more of a risk to have it in a drive lane. The other thing too, and I think this would be another good thing to put in newsletter as well, and I like having that in here, is about putting trash containers on sidewalks. I actually think that's something that not a lot of people really think about, and they put it on their sidewalk, and then people walking can't walk. It's really intended to go in the street, and that way people can can continue to walk. So I like in section 3A where we discussed that. One thing that I might change a little bit is where we say not to exceed 24-hour duration. I think that's a little short, especially if you were to put it out like when you get home from work the night before and then you get home late the next night, you're already over that. And again, I understand that you guys have discretion, but I think we should probably just extend that to 36 to be a little bit more lenient on how long like a trash container can be out there, where it's a little bit more on both ends of when it needs to be out there.
I think the trash container issue is about we have that trash can ordinance that allows it to be out there for 24 hours. We already have that ordinance. I think is that right, Andrew? Is it 24 hours? So it's supposed to be out the night before and put away by a certain time, the morning after, right? Or, yeah, the morning of or something. It's 24 hours before people get the little warning on keeping their trash cans out. That was an ordinance you guys passed, I don't know, a couple years
But you guys keep busy on that one, huh?
He gets to do that.
More important things to do.
I guess I would follow up on Trustee Jeffrey and Trustee Doherty's comments. I do think it's appropriate to require a permit for any length of time when it's in the right of way. So I don't think we should put a 24 hours or anything on that. And I disagree with Trustee Doherty about requiring people to put them in the parking spots, only because I envision that being a bigger safety issue if you have rocks dumped on the parking across the street from your house, and then you have to drag them back and forth by wheelbarrow across the road. I think that's more dangerous. But I do think that the solution to that is have the police enforce and make sure the rock pile doesn't stay there for 6 days.
Well, I have the problem I see with it, with what the point that you're making, Trustee Doherty, the problem that I think that's a good point, because when people are, the reason we can only park on one side of the road is because there's not enough room to get traffic through and sometimes emergency vehicles through if you have people parking on both sides of the road. So if you have somebody parked on the road and across the street you have a pile of rock that takes up a parking space, you've got the same problem. So you can't get emergency vehicles or you can't get two-lane traffic through. So I think that's a problem. So I think that's, I mean, the development was allowed to develop however it was back when it was developed. But now we have a problem that we have to deal with chronically with parking issues. So I think it's kind of a safety problem to have it dumped on the side where there's no parking. I think it brings a variety of safety problems. And if that means that you have to put it on your driveway and risk cracking it, I think that's your risk as the homeowner to decide how you want to do it, whether you want to across the street or whether you want to, I mean, it's just,
I understand what you're saying, but what I will tell the board is, remember, we're a policy-making body, and if we're telling people, put it across the street or put it in your driveway, we're the ones that hear about that, so.
I guess I'm wondering what the difference is, if it's a pile of rock or if it's a car, and if it stops the emergency vehicles from getting through to get to the person that has a medical problem, which is why there's only parking on one side of the street.
And the way the ordinance is currently drafted, and maybe this is too much of a burden on staff, so I'm kind of looking over at staff on this, but when they issue the permit, they need to verify that the location where the item is going to be, or the pile, or whatever it is, doesn't interrupt the flow of vehicular and or pedestrian traffic and doesn't interfere with the public's normal use. So that I think in Berkshire, as an example, if you have cars parked here and you're doing that, you are going to be interrupting the vehicular flow. And ultimately, staff, and they're issuing the permits, going to have the applicant identify where they plan to put this thing, what the dimensions of this are, and ensure that vehicular traffic can go through. And I would think that maybe we can work with the chief, because I don't actually know what kind of normal width we need, 12 feet, I guess, roughly, something like 24 for two lanes, yeah, right. I mean, not that we're gonna get out there with measuring tapes to make sure that there's a full 24, but that's still how we would permit it, so that they would only be permitted to not, if it's a one-way street, have 12 feet.
I don't know, I may be making it more difficult than it needs to be, but because people are going to dump it and they're going to shovel it into where it needs to go and it's going to be gone. But yeah, I don't know how we can, in our ordinance, say that you are allowed to put something in this area that you're not allowed to put something, right? I guess that's the issue.
Fair point. Any other, trustee Stroud?
I can't really believe that I need a permit to add gravel to my yard in any way. I guess that's what I'm trying to say. I wouldn't even apply for a permit to have a load of gravel dumped in the street to add it to my yard, so I don't see.
Not uncommon, just so you know, trustee Strzok, there's a lot of jurisdictions that do have this limit that require a permit before you can dump landscape material on the
But we
street.
don't have that, do we?
No, we don't
That's
have
what
it
we're talking
now,
about.
which is what we're,
Okay.
Depends on if
Wait
you
a
move
minute
yes
here.
or no.
I think it's more about allowing for the enforcement of a problem when one occurs, based on that, right?
I think you can tell, you know, whether the people are trying to get rid of it or if they're putting cones out there, trying to make it safe overnight or something, or if they just walked away from the pile for a week, you know, so.
But right now, we can't do anything about it.
Public Works,
Trustee Stroud, trustee Ott.
I think a 72-hour exclusion is perfectly legit. It gives them 72 hours to get it out of there, get it cleaned out, no grief, no process, no brain damage for staff, and no brain damage for you.
Across the board on the street too?
If they're gonna dump rock or something, yeah, I don't see what is a problem. I mean, how do you? Yeah, I think it's 72 hours on everything.
Anyone have thoughts on that? Trustee Doherty?
I guess the one thing that I can't get behind is allowing it in a drive lane due to both emergency vehicles, but then also if you're trying to have two vehicles that are trying to go past, you're on a corner, they don't see each other, somebody's gonna hit the rocks or somebody's gonna hit each other. It's the drive lane, that's where people need to be driving, we need to keep it clear, is my opinion. So I don't think we should have a variance to allow people to block up drive lanes through town.
May I ask a question, Mayor? So I understand what you're saying about 72 hours, whether it's on your property or in the street. So what do we do about that guy who puts the cones out in the street just to prevent people from parking in front of his house? This ordinance would have given us the power to go over there and say, move those cones. And now we're saying, you have 72 hours to block your neighbors from parking in front of your house. And I think that's a concern. Maybe we don't distinguish that, but then you're trying to get into what the intent is of why people put things on the street as opposed to, go ahead, I'm sorry.
Oh, okay, go on. I just wanted to make sure you saw me when you're done. So I think just like I hate this thing. Just like an abandoned vehicle. Currently, right now, our abandoned vehicle ordinance is 72 hours or longer. You can't keep a vehicle parked on our road without being moved for 72 hours. That's our code. So most of you might have parked a car in front of your house for more than 72 hours without moving it. So I guess what it's doing is giving us, Andrew or the code enforcement officer or the police officers aren't driving around looking for things to be there for 72 hours because there's no way we know that, right? So this gives us a tool to say, hey, you need to go get a permit. If you're in violation of this, or this is something your neighbors called and said, this pod has been in the street for a week, then we would go to them and say, okay, you need to go get a permit, or whatever. So I don't know that the 72-hour thing is necessary.
Has prosecutorial discretion as to when to go out and enforce, so that if somebody has a storage pod in front of their house and the United Van Line truck is parked next to it, the police might say, all right, something's going on there, and not go out and enforce. But if the guy's got the cones out that say no parking on the, made out of paper, taped to it, he can go out there and say, you're not allowed to have stuff like that in the street you're not allowed to ever have that kind of stuff in the street.
Can't ever have it there for any period of time to block
There's not even
somebody
a
from
permitting
parking.
process.
I understand that. Can I speak?
Yeah.
I understand that. I guess as long as, my feeling is if somebody's gonna move, they bring a pod in, they get it out the next day. I don't see where they should have to have a permit. But
If it's on the street.
it's on the street or in their driveway. But if nobody notices, nobody complains, and they get it out in 72 hours, they're not gonna do anything anyhow. So it's their discretion to make the guy get a permit or not. In other words, they see it there on a Friday afternoon, and when they come back in Saturday, it's gone. They probably wouldn't write the guy up for needing a permit.
Well, so where I live in Colorado Springs, they have this requirement. You cannot put anything. You can't put mulch in the street. You can't put your pods in the street. You can't put portable toilets in the street. I see people deliver them up people's driveways, but the cracking issue is always an issue. The truth is, if somebody dumps landscape material on a Friday night and has it out of there by Saturday afternoon, there's never gonna be any enforcement on that. But if we say that we're only gonna come after you if it's 72 hours, then all of a sudden, we really need to try to identify differences in material types that you've got dumped on the street and why you might have put them out there. And it makes enforcement, frankly, in my opinion, a lot more complicated.
Right, I think it does. And code enforcement officer just advised me that our abandoned vehicle is 24 hours, not 72. So you can't keep your car parked in front of your house on the street for more than 24 hours by our code. And we're not towing cars, I mean, for that, right? So, and in this circumstance, what we'd be telling people would be to go get a permit if they're gonna keep it there for any length of time.
I agree with all that. I think if we're gonna do the 72 hours, we should leave it to things on your own property. And the only reason I think we should do that is so that we don't have a flood of people coming in, applying for permits to have a pod in their driveway for a weekend, which might not happen, but it could. And I don't know if we have the staff resources for that. So I would put the 72 hours on the personal
Private
property.
So how are things like pods not already covered in the one that we've already passed, I thought? That covers driveways and things like that. Because doesn't it have like trailers and how long a trailer can be in your driveway?
Yeah, it's gotta have wheels on it. Specifically defined as things with wheels on it.
Okay. So am I really only allowed to have mulch on my driveway for 72 hours? So why does that matter to the town?
No, you can have mulch on your driveway with, I think what I was hearing is that if you have it on there for 72 hours or less, you don't have to come and get a permit. If you need it on there for 72 hours or more, you need to come and get a permit and tell us why. I think that's what I'm hearing.
What I think that does is helps when you've got your neighbor who's had this sitting there for 6 months, and it's just become a nuisance.
Anything else? Is that sufficient direction, or are you?
Sufficient direction. I'm going to take another version draft and we'll put it on the agenda. I can put it back up for discussion again, or I know we have some current issues in town. We can put it on for action, and again, if there's certain tweaks that you want to make.
Yeah, I think it'd be fine for action, and then if we decide we don't want to take action, we can delay vote. Next item is the events MOU. Mr. Stamey.
So I did not bring a copy of that tonight, but we have Mayor Lofgren and Mayor Pro Tem Ott and Town Attorney Duran and I and Town Clerk Blackson have met to discuss a memorandum of understanding that would identify Loch Buoy's participation in certain identified events with the City of Brighton as a co-sponsor of those events. And initially this was going to identify 4 events with a financial contribution of the town of $4,000 or $1,000 per event, with sponsorship and names on the event ads, as well as participation by Loch Buoy residents at a resident rate if there are going to be any fees for those events. So we have sent an initial draft to the City of Brighton events coordinator, and they are reviewing that and will get back to us on any modifications they may have on that memorandum of understanding.
See her email this afternoon?
I saw one where she was going to take it to was their attorney reviewing it? Was that the one?
She emailed this afternoon and said she had tentative approval from her director.
Okay, I didn't see that one. Okay. Okay.
And the other thing I would add is she also indicated that perhaps next year they would like to tie this into a giant agreement that relates to our resident rates for use of the rec center, right? So that we don't have 2 separate agreements out there. Questions or comments from anyone for Steve? Trustee Strott?
So we have our deal with the rec center, that we subsidize the people that want to go there. But we really don't, I don't know, have we had any numbers of how many citizens actually do go down to that?
Yes.
Is it worthwhile, I guess would be what I'm asking on that. And then what would the 4 events be that we would be sponsoring?
Listed it last week, and I don't know if I still have that with me.
I can tell you here in a second.
Turkey Trot, the camp out event, one of the water park
Customer
events.
appreciation component. Right around that water park.
There was a community use of the,
So I think it's
The
kind of
water
great
park.
that, we'd be to some extent co-sponsoring some of these things. The turkey trot, I think it costs the same for me whether I'm a resident or not. I think it's marginal to how much money you're really saving. Aside from how I really feel about, spending money in Brighton rather than here, I think the majority of the people that I talk to have all said that they personally feel that the town should keep the money inside the town for events for our children here. And I don't know how we accomplish that. I mean, it'd be nice if we had a ball field or we cleaned up one of the parks so that the children could be here. All I'm trying to say is that a lot of the citizens would like to see that money stay here rather than go to Brighton. So, end of my point.
If I may, Mayor, Trustee Struck, the 4th event was the what they call the trunk or treat. So there's a summer event in
Treat, yeah.
July 26th, aquatic park event, a camp out August 3rd and 4th, a trunk or treat event October 26th, and then the turkey trot on November 23rd. And to your question about numbers, one of the requirements in this MOU is that tell us what those numbers look like from participation from the town of Lochbuie so that you can make a decision for 2020 budgeting, whether or not that's money well spent or not.
That sounds prudent, so I certainly agree with that.
Anyone else? I would just respond to Trustee Strock's point and note, I think that's great, and I agree that if we could plan events of this scale using only $4,000, I would be 100% on board with making it happen. With $4,000, we cannot plan anything the scale of the camp out event, the scale of the turkey trot, the scale of the trunk or treat. I mean, we're talking about pennies to allow our citizens to participate in Brighton's events and allow us to advertise them as Town of Lochbuie events. And I think what we get for what is a relatively small amount of money couldn't be replicated by our staff or by the events committee unless we gave them far more resources than we have at our disposal. So that would be my response. Anyone else? Is anyone opposed to bringing this back for action, assuming Brighton gets the okay on their end? Okay. Next item on the agenda is staff reports. Chief McQuay.
Okay, you have my report there. I don't have a lot to add to the narrative of that, unless you have any questions about it. I do have some comments. The trunk or treat you're talking about, we do a trunk or treat. Matter of fact, I was going to talk about the funding that we were going to request from the town for our Halloween event, which is a trunk or treat. So I don't know what the trunk or treat is that the events committee is talking about. That's the first time I've heard about that, so I don't know if that's in conflict with what we're trying to do. Because we do that right here. So we're looking at doing $1,000 for that, and also for the public safety day that we'll do in another $1,000 for the public safety day. We spend about $700 for the Halloween event for candy alone. So then we need other money to try to get some of the equipment that we need. And then for the public safety day, we give away bicycles and bike helmets and things through the bike rodeo and that kind of stuff. So those things are directly benefiting the kids in this community. I don't know how that impacts that whole situation with the other thing, but so there's that. Also, I think that Mr. Ramey here gave you guys a plan of the sewer plant here. There's a couple of them here. One of them is, it shows the property running adjacent to the sewer plant. And, you know, we used to have a firearms range over here in Lake Henry. And the location of it was really actually great to shoot, but it really wasn't very great because of where it was located. It shouldn't have never been put there in the middle of what should be a lake someday. And that was a problem. So we closed that, and we do all of our range, our firearms range, we do all of that in the Adams County Flat Rock Training Center. But every time we go out to the range, it costs us $250 and to do that. And we have to reserve time when it's not always available. There's a lot of people that use that range. So I've talked to Wayne to make sure it doesn't interfere with anything in the future for the sewer plant, but get this done. So, yeah, so it's
Okay, there's two drawings. The one that it looks like this. Okay, this is what was laid out by SEH engineers of how the plant site looked up until the excuse me, the wastewater treatment plant expansion. So when you look at this site, you know, you're also saying to yourself, well, what if we doubled the size of the plant? Would we have room to do that? And then also for the police department to have a shooting range. Okay, and that's this one right here, Mr. Strzok, that one right there. So if you look at it, we could put more clarifiers over here. The police department wants to put their ranges right here up in the northeast corner, right? Shooting north to south. There's a berm already there by the UV building. It would just, we'd build that berm up high enough to where you would block the building, right? And we're not worried about police officers shooting at us. So he would be able to have as far as 70 yards and still be off of the the very north section, right, to where the property boundary is. And then where you go where the two round, those are called clarifiers, there's room there to put two more there. If you look where the aeration basin, which is this, okay, with the squares, there's enough room to put another one right next to it. When you see the digester building, you know, we probably won't need to expand that very much when you double that up, but you still got enough room over here. And then the other one was kind of to show that we are adding on to this little one, right? You can see how it's getting a little bit bigger on the drawing from JVA. But when I say bigger, it's only 70 feet long, right? It's not that big. When you consider that there's close to 400 feet between the two, 60 feet is nothing, right? So we got plenty of room. And we would still need, like you see on the very north end, which is the far left of the site, we would have a road put in there anyway just for the dewatering building, because that's where the expansion will be, where we put in an actual building just for biosolids and dewatering. So you need access to the road to get out. So we would have an access road to where the police department would be able to get back. So as far as me and my personal opinion, I don't think it'd be an issue for them to set up a range out there. There's plenty of room to handle twice as much capacity as we already have. And when you consider that, right now, we have 1 million gallons of capacity for Lockley. Well, we're only using 30% of that, right? So we got, if you double that, and whether Brighton got another 1 million, and we got another 1 million, the town of Lockley, you know, when you plan for 20 years, that'll definitely get you 20 years. And if it's, you know, and it's probably not going to be a huge, you know, structure that the police would put in, that if it did require to move them out, well, you see if you could buy some more property next to it, or we'd take up the room for the wastewater plant. But, you know, they're not putting in a cathedral out there. They're going to put in some berms and some dirt. Right? Recycling, like if you're worried about lead, I'm sure that'll come in your mind, you know, just based on it being a shooting range. Well, my idea would be to put in recycled tires, you know, what they put on playgrounds. That's easy to screen that out. it doesn't deform the bullet that much to where you can screen that out and even reuse it for it. And you just put down a weed barrier on the bottom of the berm, just to keep it from making sure as it rained, it didn't leach anything down. But I mean, it wouldn't hurt the environment at all, trust me. And think about it this way. One of their bullets, okay, 110 grains is about 9 grams, right? There's 450 grams in a pound. So if they shot one bullet at 9 grams to get to a pound of that, well, you know, you're gonna have to shoot 50 bullets, right? So I could say to you easily, it could hold a ton. Do you realize how long it takes to accumulate that much? They'd have to have every cop out there 8 hours a day for 3 or 4 years. So you gotta put it in perspective of how much the bullet weighs, how much lead's actually there. And if they use full metal jackets, some of those could be even copper, right? So Tracy called me, I looked into it for him, I don't have a problem with it at all. I think it'd be good for you to have well-trained officers.
I hope we're still doing that anyway. So I'm just bringing this to your attention to let you know that it's something that we're thinking about doing, we're talking about doing. We would do a horseshoe berm to basically encompass about 20 to 25 yards, which is what most handgun shooting is. If we did any work with the rifle further than that, then it wouldn't be inside the berm, you'd be shooting at the berm. But it'd be safe, there's nothing out there. And it would be great to be able to go out there whenever we need to go out there to do a shooting instead of having to reserve it and pay for a spot someplace else. We have reached out to this tire recycle place, I forget, just down there, it's not very far from here. And they're willing to donate us some shredded tire and help us out with it as well. So I kind of wanted to get your thoughts on it and see if there was any red flags or anything that that folks had, because sometimes this can be controversial. Although the amount of rounds that we're going to be doing, it's not going to be anywhere near the level of any type of public range. It's very minimal amount of time that we'll be out there.
Comments for Chief? Trustee Morris?
I think it's a great idea for you guys. Could we open it up to the public too?
Oh, that's a whole nother deal right there.
Trustee Strapp?
Well, I know the original shooting gallery that you had out there, you know, it was kind of before your time. My complaints originally was all the brass that had just been left out there.
Yeah, that's not okay.
Never reclaimed any of the lead in that hill either. And aside from that, you know, you were shooting 223s over at the tree farm. And then when you wanted to, I'm not going to say you actually missed the target, but the tree farm was behind the target. And then when you did the other dig out for the other shooting thing, you know, the other side of that was I-76. So those were my only problems. And as long as it's positioned in a way that you're not shooting at the highway accidentally, I mean, accidents do happen. I mean, I'm all for it. It's easier for you to go out there. I don't want you to lose any of your, the benefits that you have out there at Flat Rock. It's a great training facility, but I'd certainly stand behind you on this, you know, as long as you pick up your brass.
But we would continue to train at Flat Rock when we need to for certain things. My opinion is we should always be picking up our brass. Matter of fact, I think we should be picking it up and reloading it to use for, again. So I don't know why anybody would leave their brass out there.
Perfect. Thank you.
My one thought is it might cause any increase in calls that you guys get for anybody in kind of the local areas, just from a sound thing, that we're hearing gunshots.
Yeah, I think that you'll probably get that when you first open it up, when you first start doing it. And so when I first started working here, that range was down there on Lake Henry, and we weren't getting any calls at that time because they had been doing it for quite a while. But we get calls too, and when there's hunters out in the fields and, you know, bird season, we get calls. Yeah, I think you might get a call or two until people understand that it's there. Then I think that will, and unless somebody else moves in, then they'll call again, you know. But I think that's something we can work through. And it doesn't really, it's not going to cost us much, I don't think. I think we can do most of the work. I think we have most of the dirt already. So I think we can do it ourselves.
Does anyone have any objections before we send Chief?
Okay, thank you very much.
One question.
Yeah, go ahead.
So Officer Dunham resigned, I guess, and,
Right.
and I guess it's probably really none of my business, but I do know that the SRO officers at the school kind of have a trouble with the schools expecting the officers to take over more responsibility than they really should, and the schools aren't really always accepting the problems that they have and trying to solve them. They're just trying to push them off to the SRO officers, and I didn't know if something like that might be part of the problem with his resignation.
Yeah, I don't know that there was necessarily a problem with his resignation. I think that he's been, you know, he'd been playing with this for a while. I think he was about tired of it, the whole thing. But I also think that it's a balance, and we have to, the SRO has to be the one to work with the staff out there to balance that. So, because it's important. I mean, the school district is paying a lot of money for this. So I think it's important that they have some say and some level of ownership in that SRO. So it's not like we're providing it to them. I think if we were providing it to them, then we have a little bit more, we can be a little bit more restrictive maybe, but we want to have that relationship. And so I think and that makes it tough, right, for the SRO, but I think that it's an important thing that he finds that balance and is able to work together with them.
Thank you.
Anything else for Chief? Okay, next up is Public Works Director Beback.
Just a quick summary and what's happening in our department, and everything is going well. Since I typed this up last week, actually, we extended an offer to an operator, to a gentleman for this operator one position. He accepted. We're going through the background and the pre-employment stuff, and so I'm looking forward to that. Also extended an offer to one seasonal guy, and he's expressed interest to start as soon as possible, so that's good. So at that point, we'll have just one vacancy for a seasonal person, and hopefully we'll get an applicant for that. Haven't had any applicants aside for that gentleman for that position. Otherwise, everything on track. As I mentioned to you a couple meetings ago, we have an RFP out for on-call engineering services, and actually pretty good response to that RFP. Solid engineering firms respond to that with good proposals. I assembled a 3-member panel, myself and Wayne and Sean Hearn, who's the managing partner of Inertia. And we scored all those proposals, and then I invited 2 finalists. The goal was to ask them some additional questions and meet the staff in person. And this isn't a request for approval of their contract. This is just a summary of what we did so far. But so I haven't finalized that, but we invited Baseline. It's an engineering firm out of Golden, and we invited Martin out of Lakewood. So I'll have that for your actually on the 7th. I'll have a recommendation for you on the 7th. The other RFP on the street is for pavement. Our current budget is somewhere around $380,000 for pavement improvements and fixes. So I'll just list it out, all that. This is a summary of what's in there. Essentially, the biggest piece is the Weld County Road 4, addressing all the potholes out there. Some of that crack sealing has already happened in 16 before I started from 37 West, but we'll just touch up a little bit crack seal on that section, and finish up crack sealing that, will chip seal. And the other areas is just regular slurry and lockwood, and hopefully the proposals come in under budget and we can address all the bullet points. I'm not 100% sure we'll be able to actually complete all the work. It's just wishful thinking here, but keeping the fingers crossed. A couple other things, kind of excited about this GPS purchase. We just bought one finally. It's here, and I just spoke with Precision, Frontier Precision, which is an outfit out of Arvada. They specialize this sort of stuff. They'll help us get that set up on my computer, on the computers in Public Works. So with that, they'll also help us to transfer some of the existing digital maps that we have, and we'll have everything in-house. Anything that gets installed will be automatically uploaded onto our database here in town. Any other repairs or any other things that we do, I'll have a protocol where we'll go out, we'll GPS and upload that stuff and keep adding to the database of GPS points. So I'm excited about that. The other thing I'm excited about is actually is UTV. Where after the recent snowstorm, I've been thinking how the level of service we want to provide in terms of plowing sidewalks, and I know there's going to be plenty of sidewalks being built with the County Road 2, and I just want to do better going into this next winter. Instead of running our little ATV, I wanted something more solid, more stable. So we'll be looking at buying that unit with a small plow, and I think it's just going to be more efficient and safer doing that this winter. So that's what I have in terms of my summary. Got any questions?
Comments for Mr. Beback? Amen. Thank you for your update. Next up is Mr. Amy.
Does it work? Okay, good.
I think you need to, Wayne. You're very hard to hear.
You know, Rudy Valley or something starts singing, and God, then you guys would throw me out of here. I was just talking to Tracy. When I worked for Broomfield, when we made the sheriff's department range, we did that in Public Works. It's not expensive. We used tires, right? Like the real big tires. And then we laid it out, we made pyramids, and we fill it up with dirt. Not only is it cheaper than dirt, because it's free, it's actually a really good sound deadener. So those of you worry about the sound, you could be right up next to it and not even know they're shooting. So I even got a personal thank you from the chief of police in Broomfield for it.
Oh, good.
He wanted a helicopter. I gave him a gun range. Yeah, I will. I'll help you design it so it comes out right. It was fun. We had a good time. Well, who doesn't like playing in dirt, David?
Yeah.
Right?
All this stuff, you haven't mentioned who's going to build this thing.
So you guys got my report. As you can see, the influent flows up a little bit. You know, so it was a dry month in March. You can see we didn't have much groundwater flow, so that just lets me know that there's more houses coming on by the moment. No real big issues. We are looking at the flow meter over at the Brighton lift station. That one's giving us some fits, so we're probably gonna have to replace that. You know, it just keeps drifting, right? We go over and we check it on the readout to the staff gauge that's in the flume, and you know, it's pretty close. I mean, with the naked eye, but you can see the trends are kind of weird. So I had a guy come out, troubleshoot it, so we'll get some bids to replace that, because I know that's one of the agreements in there. The wastewater plant, we had 2 major shutdowns. Those all went really well. To tie in the motor control center, those went real well. So we'll have another shutdown probably in May to tie in the influent lines from the new lift station up to the treatment plant. You know, the plant didn't get upset, only because we got plenty of capacity, and so it was easy to take basically just store flow for a day and then slowly trickle it in after they got their tie-ins. It went pretty good. So that should also save us on some of the extra additional charges that Mulch might have gave us. Water plant's running good. We got to replace the chlorine pump which wasn't a part of the original water plant expansion. It didn't include a new pump, so we got a new pump we gotta get. We've been doing some calibrations regularly. Well, the RO guy was up assessing the membrane. She's gonna give me a report next week that I'll have for the board next month on the condition of all the membranes. And then we're talking the old ones, because the new ones they're fine. And then also some additional blending valves on those old ones, like the new ones came equipped with. And he'll also provide us a scope and a price for the SCADA to tie the 2 treatment plants in. So I got another guy, I got two other companies giving us quotes for that too. So I'll have that for you here in the next couple of months, but other than that, everything's going good.
Questions or comments for Mr. Amy?
Dewatering will be started up in 3 weeks. We will have our own dewatering unit. That'll be cool. Still be under construction, so we'll wait and show it to you after the contractor gets out of there, but yeah.
Crazy question. So after trying to figure out this consumptive use water, et cetera, et cetera, et cetera, could you take your total production for the year and divide that by the 0.6 of an acre foot of water and come up with a number that would be relatively close to our population?
Yeah, you bet. You bet. Now see, now, and here's where the only anomaly we have when you look at that is the reject water on the RO, right? That is a non-consumable commodity that you buy. So in other words, like if you buy 1 acre feet and we run it through the RO, right? We treat a half or almost 70 or 70% of that, but out of that 70%, 25% of that goes to the wastewater plant. So you see, it's hard to say on what we buy as raw water how much our consumption is, right? But now also that reject water doesn't hurt us though, because it also is part of your augmentation plan, right? So it does count as how you pay the river back for what you take. Like Mr. Jeffers says that you have to return part of the flow. So that's what we count that as. Okay, so that doesn't hurt you, but from the treated water side, by all means. And I can tell you it's running about 0.45 acre foot per household per tap.
That seems about right, doesn't
Yeah.
it? Yeah.
Like in the wintertime, you guys are like 0.16 acre feet per household during those cold months, which turns out to be about 260 gallons a day per household. Right, so that's about normal.
Yeah, I taken once, tried to figure out just about how much you use every month as a family and stuff, and it's right in those ballparks, you know, that 410.
Yeah, there's no, here's the cool thing about your system. Like we don't have a lot of leaks, and the sewer system's pretty darn tight. Right, so you don't have a lot of infiltration that comes in. Now the groundwater down at the plant, yeah, because you're right along that canal, that BBC, so groundwater's high. So we keep that dewatered to protect the structures, and so we put that out through the discharge. At our next permit renewal, that may come in to play based on as you guys remember when we first started, we had to do a compliance schedule where we had to do a study on that groundwater and infiltration in the plant and how does it affect our effluent. So that may come back, because we still do that. I mean, we still do that testing, only because when the time comes to where we need to negotiate that permit because they might put something onerous on us, we got the background data to hopefully not be so restrictive. Right? I won't say back off, but it's like so they're not so restrictive.
Thank you.
You're welcome.
Questions or comments for Wayne? Seeing none, thank you for your update.
Oh, you're welcome.
Mr. Stamey.
Thank you, Mayor. Just a couple of updates on development. On the Silver Peaks project, we did receive a submittal for a subdivision application. This involves a large parcel in Planning Area 4, which is just east of the new elementary school. They have a subdivision to divide that large tract into 122 lots. So we'll be processing that. And we've also, Maureen and I had a conversation with Jen Ruby, the Walton representative, about updating their some pieces of their annexation agreement, as well as with this subdivision of this, addressing the County Road 2 timing for construction, and trying to change the language right now from its kind of, I guess, unclear language, not really enforceable, to a time and date specific of when the construction would actually start. So we're looking at doing those kinds of things with this review. And secondly, Silver Peaks East, there's an update on that from Michael Blumenthal, that when D.R. Horton a couple of weeks ago or several weeks ago was doing more subsurface investigation, there are currently 25 lots which they have determined they do not want to buy because it would be very expensive for them to solve the organic material and groundwater problems on these 25 lots. So they will be amending their subdivision plat. We've had a couple of conversations with Mr. Blumenthal and his team to place those lots into an open space tract, which also involves removing some streets in that portion of the subdivision. And then we would need to amend their water resource credit agreement because of fewer lots, and also their subdivision improvement agreement to reflect these changes. So there'll be a process of coming back through.
The lots in Lake Berkshire?
These are the lots that had the kind of where the cattails are and kind of the ponding water that we've had complaints about for the last several years. Well, that's part of what we want to address, is what happens to those. There is a drain pipe as part of their final plat and construction drawings that connects from that area under County Road 2 into the South BB draw ditch on the south side of 2. So we want to make sure that that drain pipe still happens.
I want to add a drain pipe after we build the new road.
I don't know what the timing of that would be, but it'll be with, my guess is if they approve this, again, the Silver Peaks, the Walton piece starts building, this would be under the Walton piece of Silver Peaks construction, and all be coordinated hopefully with that culvert crossing, it'd go through in that area.
Just envisioning finishing the brand new road and then tearing it up 6 months later.
So it creates a big open space over there now?
That's correct.
Couldn't happen to a nicer guy.
So with 7-Eleven, so with tonight with the water resource credit agreement with Lockbuoy Station and also with the resolution for the Lockbuoy Center plat, we have really finalized the 7-Eleven review, and I met with them to finalize their number of water certificates they need to bring in. So that should be moving forward soon. Their schedule would be to start construction probably around the 1st of June, and they have a 90-day construction window. So it'll be around Labor Day. That's all.
San Diego's is finished in Brighton. Have you heard anything about them coming to Lockbuoy?
I had a phone call from can't remember her name. The lady who's been in is going to operate this franchise. She called and said, "We haven't forgotten about you. We're still moving forward." So just wanted to touch base. So nothing.
That's better than nothing.
Yeah. Okay, it's better than nothing. This much.
So no new schedule.
Thank you.
Did Jen Ruby give you any pushback on trying to get a date on County Road 2?
No, I don't think so. I think she understands that we have interest in getting the road started.
Else from anyone? Okay, we'll move to Mayor Trustee. Any other comments from staff? Okay, we'll move to Mayor Trustee comments. Trustee Ott.
CML's all the controversial stuff has been passed and signed except for the family leave deal, then they're still fighting over that. Because basically almost every municipality and every business in Colorado is totally against it. So they're revising that. So the family leave deal is still in the air. But the rest of the stuff is already passed and signed, and so everybody knows there's 3 referendums that are gonna be on the ballot probably, and 1 recall. So, 3 referendums to overturn legislature.
There's three efforts to
Three
get
efforts to
referendum.
yeah. Well,
It's
one of
very
them already
different
has
than
enough
saying they're
signatures.
probably going to be on the ballot.
One of them already has enough signatures.
Okay. Trustee Doherty? Trustee Jeffrey?
I am not going to the library board meeting tomorrow because it is a very short agenda and not really anything new than what they discussed last month. That's all I have.
Brock?
All right, well, tomorrow night at Dr. Cog, the Finance and Budget Committee will discuss increasing the 2019 funding for Volunteers of America for the 2019 year. You know, they supply 507,000 meals in 1 year to over 4,000 people. I mean, that's incredible, you know, and they just need another 600,000 for that. They're also going to talk about continuing a contract with the Colorado Department of Human Services where they can help. Together, what they do is they distribute the $18.3 million that's available for older Americans and the state funding for senior services. After that, then Dr. Cog is going to discuss some transportation amendments to some of their TIP funds and stuff. They'll also be discussing their position on 17 different state bills that range from protection from unlawful abandonment and confinement of elderly people down to mobile home park acts that will give people more stability. The best of tomorrow night will be the sub-regional presentations for the funding. There are 112 projects totaling $385 million, and there's only $209 million available. So it's still a 50-50 crapshoot. So that's about it for me.
Trustee Morris? Trustee Connerman isn't here. I could ask him if he has anything. The only thing I have is I will be attending the Berkshire annual meeting tomorrow night. Apparently there are several citizens from that neighborhood that have questions about County Route 2 and several other things that are going on in town. I encourage any other members of the board, especially those of us that live in Berkshire, to attend if you can. Clearly you can't. You have a more important meeting. But they do appreciate when we show up, and it's a good way to help answer some questions from people who don't necessarily come to our meetings. So that's all I had tonight. I will entertain a motion. Oh, yeah.
United Power Banquet is tomorrow night also, starting at 4:30 at the.
I have a motion. Do I have a second?
Second.
All in favor?
Aye.
All opposed? We are adjourned.
I'm done, that's fine.
That's pretty funny.
Shut up. Somebody's
Somebody's gonna start moving